Live should be good. Let's see. Bear with me here. This is giving me a little bit of difficulty. Bear with me. What the hell? There's that. Okay, end stream. All right, so we are live, and here's the recording. The recording is good. Okay, so here's what we got, guys. We have probably the most complicated play that I've ever seen on Wall Street, and that is MMTLP. Now, I have with myself much wiser people than I. That being Alan and Alex. Alan is in the process of writing a book. Alex, I do not know as much about your history. If you'd like to introduce yourself, but I know that you did have experience as in a former SEC attorney.
Yeah. So I'm a corporate and securities lawyer. I used to work with the Securities and Exchange Commission, and I worked at one of those big giant firms. And I headed a practice, founded 2 companies, exited 2016. Moved into blockchain then. I've been there since then. Mm-hmm. And I'm chief legal officer of a platform, and I have a podcast called Crypto Immersion that's just unbiased information about finance and blockchain. And I've been asked to write a book on DeFi, decentralized finance, and by a publisher, and I'm about 2/3 of the way through that.
I would love to pick your brain at a later time regarding that, but now while we wait for Neil, because I don't know what he's up to. He's actually an ex-hedge fund owner that's supposed to be joining us. But anyways, Alan, can you go ahead and can you explain to us a little bit about what you have going on with MMTLP, please?
Sure.
Yeah,
so.
Sorry, Alan. Apologies.
Oh no worries, Alex. Did you have something to say? I'll get out of the way.
Not at all.
Okay, so I started as an investor with MMTLP, and I started noticing little things that seemed weird to me. I like to always look into the company history and background, and the more I dug into it, the more weirder things got. And so I decided, well, I'm going to write a book on this, because as this transpires, I can get current active information and try to keep my book current with times. So as soon as we end up figuring out what this is going to be and how this is going to transpire, I'll have the information firsthand and be able to hopefully produce, a book that people would be able to follow exactly what happened, because this went in so many different directions.
I agree. And what do you think your plan of attack is looking like, versus what do you have against them as of right now?
Well, so that's the thing. As of right now, my course of action has kind of changed, because I went from being a person that was an investor and trying to write a book to somebody that people are asking questions. And so I'm doing a lot more research than I was even doing initially. And I understand the processes very well and how the different organizations interact and work with each other whenever we do stock transactions. And so I was able to kind of clear up some things and really help people understand how certain things work. And so I've now turned my attention to the SEC and trying to get them stopped, the folks that were defrauding us, and all of the stuff that they've been doing that I feel like is very egregious and very wrong on how we've been treated as investors, as company owners, for the folks that were Torchlight, the board members. I mean, everybody's been attacked in all directions.
Yeah. I'm definitely not going to disagree with you.
I mean, it started with a company that legitimately was trying to make a merger and become a private business that was no longer traded, and somebody took a placeholder because of one word on a stock and was able to fraudulently get it traded.
Yeah.
I
see.
They put way more shares available to trade than were actually available.
Yeah. No, I absolutely agree. I mean, as far as hurdles go, in order to prove his case, Alex, what do you think? What do you think his biggest hurdles are going to be?
So I've talked to a number of people involved in this. I personally am not involved at all, other than I am not actually, I don't even remember how I got added into these discussions. But
I know how you got added. That was because of me, actually.
Oh, yeah? Because I remember. Yeah, what happened?
So a friend of mine, Sean, he's part of our group. He says, hey, I've got this guy that I've been talking to for years who's a friend of mine, and his name is Bam, and I think you should get him on one of your space calls. And I got a hold of Mr. Berta and said, hey, we're going to have Bam Investor in here. Do you want to come and join us? And he was like, sure. And then Bam brought in Pedro. And Bam and Pedro brought you into the mix.
That is right. That's right. So I get asked, periodically, like, can you help or explain this or whatever? And so, it's kind of, I'm just trying. I'm not providing legal advice. I don't represent anyone. I'm just trying to help clarify things, because for the most part, I mean, law is dense as it is. It's very dense for people who don't operate generally in the securities industry and don't really understand even the series of transactions that have to happen in order for a stock to go from an issuer to a buyer, or from one buyer to another. And that is something I think is problematic, and I have issues with our educational system, but none of that is really relevant right now. So I'm going to say, honestly, the biggest hurdle that I see is the same hurdle I see for a number of groups that have legitimate issues, but a lot of people that have a lot of money at stake, and unfortunately not a lot of background in this field. There tends to be a great amount of discussion around conspiracy theories and who to blame, and it's very emotional, and it's understandable. A lot of people, these are not people that have, thousands of dollars to just, let it disappear and not say anything, right? So that's the way the market is. It's filled right now with retail investors that are making decisions with too little information. But at the same time, the problem is it becomes more a discussion of conspiracies and things like that, rather than based on factually what happened. Let's unravel the string from the actual event and see where it leads us, right? So
that's correct.
So generally speaking, your first course of action when something goes wrong is, okay, take, like a couple of days, have the pint of ice cream, pour chocolate sauce on it, have a cry. It's totally understandable. Do that. When you're ready to address it, you have to cling to facts, because everything depends on those. So you take the facts that I put this in my account on this date. I received this on that date. What did you receive on what date? Let's look at the documents. You have to go back to the facts only. And you can't try to attack a particular group or defend a particular group. It has to be just based on facts. That is essentially, as you gather those facts, it will become clear what happened. and you will be able to build your case with the evidence that you have based entirely on fact, and more parties are going to be willing to take you on as representation and are more likely to be able to help you find relief in some form simply because you have facts. Most people that are especially like lawyers and accountants, and when they're not personally involved, a heavy onset of emotional response is not conducive. So the first thing is always just tame your emotions and build on facts.
Yes, and can I add just one thing to what you said?
Sure.
A lot of people, I feel, are trying to look at the laws, and they don't understand how the law works, so they take one specific sentence and they run with it, and they have no idea that the law requires multiple things. Like, you have to know what the law says, you have to know how it was applied, what the intent of the law was, and what rulings have happened in the past and how they've used that and applied those. And so they'll take just one little piece out of what's written and say, well, they have to do this, and have no idea how the courts have ruled in the past and what they've actually done with that piece of information.
I mean, I totally agree. I think one of the best and worst things of audio media, social media in general, but audio media in particular, is that you have, on one hand, this ability to gather people that haven't before been able to locate one another without extreme expense. So for this group to find one another, somebody would probably have to file either a suit, or it would have to be during one of the proxy contests where they actually got the list of shareholders and were able to address them directly. None of that is needed. A hashtag alone can essentially create a company shareholder meeting. That's pretty incredible. The problem, though, is people in general, not specific to this group, just people in general, are terrible at determining expertise. And in the absence of information, truly what ends up happening is the people who have the most charismatic personality or the most, I guess, dominant sounding voice seem to carry more weight than they should. And I have heard so much legal, tax, and accounting advice given out from people who have no background in that.
Yes.
I always ask for credentials. Ask for credentials. Are you want to get information about how to deal with bankruptcy procedure from that person? Go look him up. Oh, wait, he's a life coach?
Yep.
Probably not be your best source. There are a lot of people that think that if they've gone through a proceeding, they are therefore now experts in it. But that's basically like saying I got arrested, and so I'm now an expert in criminal justice. Not really.
Now, Alex, that actually brings up a huge point, and that's why I want to have this video to just kind of cut through the rumors, cut through this, that, and the third. I want to get to straight fact. And I appreciate, obviously, how candid you are being about that. I have a question for you, and, this might be a little bit tinfoil hat-ish. That's fine. I accept that. But one of my biggest concerns is actually the fact, it's not the U3, okay? Because of the settlement times, right? Technically, if it's settled after, what was it, that Friday or whatever, that it would have expired, or it would have been quote-unquote deleted, right? So my theory is that the original wrongdoing was them allowing it to trade to begin with, and then they almost knew that a U3 was going to have to, pop up, simply because, the shares would technically be worth zero. And that's something that bothers me. I mean, obviously, I want to trade just like the next person, right? Like, I want the last 2 days just like the next person. But I have a feeling that the government's going to try to stand on the fact that they were, quote-unquote, trying to protect retail. And that's kind of, I guess, something that I would like to have addressed if possible. Also, real quick, I want to go ahead and introduce Neil. Neil is a former hedge fund manager. He just popped into the phone call. Thank you very much for attending this, Neil. We do appreciate your time. I'm going to go ahead and I'm going to let Alex just run with it, though, because she's absolutely killing it.
Alex, just a quick question for you. Most of this is really contract law. versus torts.
Okay.
I would actually disagree on a bit of that. I think that there's some contract law here with respect to what did the merger agreement say. Hopefully people who are listening to this have some background in what these transactions were. But, you know, the first thing we need to look at is what did the contract say was going to happen with these preferred Series A? When were they going to be traded? And did the contract definitively say that the merger could only take effect after all trading with the Series A had closed out? Now, my understanding is that thing said that there's absolutely no trading on that because they are completely restricted. We're now in securities law, and the securities issues are pretty profound here, and they bring up some really big holes in our system. And I think that, sorry, go ahead.
No, I was just saying I agree with you.
Yeah, I mean, I think that there's a lot to be said there, and the good and the bad. The good is that this is displaying all sorts of issues that haven't yet been addressed. I mean, only in 2005 did this. I think it was 2005 when Reg Show, or whatever the short selling regulation that came out, that actually closed a few holes. But I mean, short selling existed for decades before then. So I think that, you know, it's I guess better late than never. But I think what's going to happen here is it's going to expose a lot of holes. And while that's good for the future, I would just like to be sure that at least this doesn't provide essentially like, you know, a group of guinea pigs for, oh, well, there's a hole there. Oh, okay, well, let's, you know, let's make sure we close that up for the future. There really has to be some grant of relief, and that is actually only through specific cases. So here, some of the issues are absolutely from the very beginning, we follow the train. So first, were these shares tradable? My understanding, I haven't seen the agreement, but my understanding is they were specifically listed as not tradable shares. The second, how did they get traded? You don't get to just list anything you want. You actually have to have an issuer submit a bunch of documents in order to trade for the most part. So how did that happen? How did the issuer agree? Or if the issuer didn't agree, immediately you were concerned about fraud. So once you look at the issuer, how did it trade? The next part is how were there so many shorts given the available purchase? Now, there are particular carve-outs for what are called locates. So when you borrow a share, you're supposed to not borrow a share. Like the market maker cannot loan you a share that you don't have the share. You can't sell something you don't have. So they loan it to you, and then eventually, you close out your transaction. But you're not supposed to be able to loan a share unless you have located a specific share that can be attached for the purposes of that particular short. When there are no shares available, there should be no shorts. But there is an exemption for what they call like legitimate ongoing market activity, and that is essentially. Go ahead. Sorry.
No, I leaned back in my chair. I don't know if that made a sound. I'm sorry.
So that is essentially, this market activity is for fast trading stocks where there's a lot happening and you can't actually locate a stock in time. And they tried to close that up by saying you're still required to locate that stock and close your transaction. That's a huge issue. You must be able to close your transaction. So there are several places you can look for all of these transactions. The next question is, where were the market makers looking to locate their transactions? Did they confirm that there were shares that could be attached to all of these shorts, or were they making shorts without a share backing it? Right? That's not an okay thing to do. Mm-hmm. Okay, so then after
we're seeing a lot of it, though.
What?
I said we're seeing a lot of naked
Oh, naked shorting is a big problem because you can't close out your position, and Reg SHO specifically discusses how you have to close out if you have failure to deliver, for 13 consecutive settlement days, whether or not you're a threshold security, and if you are a threshold security, what happens if you haven't closed out your position. So there's all sorts of requirements of what must have happened between the DTCC or NSCC and all of the market makers. Once those shorts were open and the position, like whatever their positions were, there was a process that they had to go through in order to close out their positions. They didn't do that. And that's primarily, it looks like, right? It looks like they didn't do that because there were not enough shares for the position. But that is an error right there, right? You're not allowed to have more bets open on a stock, right, than shares of stock outstanding. That's a huge problem. That is something that is endemic in the industry because people see things in real time. They decide that they want to take out a position, and it looks like the market makers are not necessarily following these rules. If they're not following these rules, they do have a supervisory authority, FINRA. FINRA is supposed to make sure that first they have rules and policies in place, and second, that they're actually employing them. Mm-hmm. So clearly someone in here has fallen down, right? And then the next part of that, of course, is the fact that the preferred shares were withdrawn from registration under the articles of the company. So the shares were said to have been converted into what was promised to these people, to the shareholders, but the shareholders are saying that did not happen. So now we have a canceled security that was supposed to be converted into something but wasn't. And it can't be converted into something because we don't know who all the holders are, because there are a lot of these open positions. You can't have open positions and close out a category of security. So those are some of the major issues. I know there's a lot. Hope that was helpful.
It was so helpful. Go ahead, Alan. You know so much.
Can I back you up, because you just went through so many things so fast that most people don't understand a lot of this. Can I just ask you a couple of questions, Alex?
Sure.
So is it fair to say that the FINRA systems that issue halts like a U3 are a lot of times an automated system? So if a entity like the NSCC was seeing a lot of fails to deliver happen all of a sudden rapidly because a bunch of people said, you know what, this is getting really strange for me, I'm just going to go to the next bridge, I'm done. And they start asking their brokers to transfer, and then all of a sudden a bunch of fails to deliver happens. Couldn't the U3 halt have been an automated process when the system saw certain market conditions? It went, whoa, we have a problem, stop everything.
So to my knowledge, no, because what they were stopping at that point was not trading, it was clearance, right? Those were the last 2 days of clearance. So trading stopped, and then they had 2 days to clear, so that U3 didn't actually help anything. The U3 would have helped if there were still trading days, but there was no trading days. The other part of that is that I don't think, while the U3, when you enact a U3 or any of these halt codes or whatever, when you enact them, you enter a sequence, a code sequence or whatever, and then the process is automated. But I do think that there is a person that initiates it. You have to have a certain set of documents, to my knowledge, right? You have to have a set of documents that are okay that for you to halt activity, because it's a very serious thing to halt trading activity.
No, I understand that completely. Can I ask you this as well? Do you feel like the U3 should have been initiated when John Berta called FINRA first and said, hey, we have a big problem, this wasn't us, we didn't do this, and he said he alleges fraud? Shouldn't that have been the extraordinary event that triggered the halt way back then before we got to this point?
So I don't know enough. I don't have enough facts in front of me, but to my knowledge, if this, as soon as someone realized that this was trading and it was not supposed to be tradable, then that they should have, and I think that the John Bird is the CEO, or he was at the time. I think that he was the one who went and notified them, hopefully by something that he has proof of. And yeah, that would have triggered the trading halt because these were not legitimately on the market.
And that's how I see it as well. I've been looking through a lot of different information, and I have been trying to find anything I could find that actually lays out, what is supposed to happen in these types of situations. And it's very difficult because you have the DTCC, you have the NSCC, and you have the OTC markets, and you also have the FINRA, the SEC, and you have the Securities Act that all overlap for different parts of this. And so it could be governed in a bunch of different ways. Does that make sense?
Okay. I feel like every answer is like yes and no.
Sure.
Yes, it absolutely makes sense. But in reality, no. There are a lot of different transactions that cross regulatory bodies. And they often have a sprinkling of SROs, these self-regulating organizations, in as well. There are processes for these, usually over time, a very clear set of processes of like, you do this part, you do that part, this goes first, then send to that, this is outlined here, then goes there. There's already a procedure for most of it. So even though there are entities that share jurisdiction, in reality, what they share jurisdiction over, those are distinct things. Like, FINRA would say, well, this was approved by these market makers and DTCC closed it, right? They cleared these transactions or didn't clear it and left them as FTDs, failures to deliver. And DTCC would say, well, wait a second, the market makers were the ones that originally allowed it to trade. So they're the ones who are liable for getting us into this mess. And why didn't you stop them? So really, it's you and the market makers, because FINRA oversees the market makers, and the market makers would say, look, we were just told to do this. It's not our job to check signatures or whatever, so this is FINRA, and you guys were the ones that left them open and didn't close. So you see why if there is a lawsuit, you have to include all parties, because otherwise you can have all the parties escape compensation and accountability simply by pointing the finger at one another. That's what's really important. It's not really that important to the shareholders who's responsible. You just have to know the parties that had a say, and then let the court figure it out.
So you don't feel like, because like FINRA's mission statement and what they have said, publicly on their website, that we're here to protect investors. We have these processes, and they list their rules, and so they have all these things that are set in place to protect us. Well, the DTCC has the same type of information on their website. If you look at their bylaws, that specifically they have things in place to protect us, and independently, all of these separate entities failed to protect us, and they all have this language all over their websites and all over their documents that they have put forward to the public to say this is what we do to protect people. When none of them did any of those things, don't you think that individually holds them to some kind of liability? The fact that they say, hey, this is what we're here to do, this is how we're going to do things, and these are the systems we've been put in place to protect you as investors and companies, and then they fail to do those things. Doesn't that make them liable?
I completely understand, but I'm going to read you this quickly.
Sure.
We will deliver high-quality products that are beneficial to our customers and for the environment through sound and innovative science, thoughtful and effective stewardship, and a commitment to safety and health in everything we do. That is the mission statement for Monsanto, which creates a bunch of pesticides and things that have been shown to be terrible for the environment.
Right.
So unfortunately, mission statements and general thoughts are not something that have legal hooks in them. They're really guidelines. And so historically, we haven't really found much of a hook in a mission statement or in an intention. What really matters is the action. Did they comply or not? Most of this stuff is called strict liability. So strict liability happens when you're dealing with agencies, like any of the federal agencies, and that means intention doesn't matter. So when you get pulled over for running a stop sign, the police only care, did you do it? Right? They don't care that it was night. They don't care that you sneezed at the moment that you passed the stop sign and couldn't stop. They don't care that, you just dropped something on your foot and you were trying to pick it up. They don't care about that. All of that goes to how much you will be punished. But the act of doing something wrong is all that really matters. And so that's when we look at these areas, we have to remember that we are bound by what is the law. And remember, it's way more than just what's written in the regulations, right? There's all sorts of law and stuff. So what does the law require, and was that requirement met? That's literally it. That's what you have to do. Was the requirement met? Now, if they tried to meet it and couldn't meet it for some other reason, then that is like an extenuating circumstance or something that might mitigate the amount of liability that they have. But overall, you look at the rules and you say, did you do this or did you not do this? And if the facts show that they did it and they weren't supposed to, or they didn't do it and they were supposed to, then they're liable. And then the whole question is, what are you held accountable? Like, how much is the compensation? What is your penalty? That's the way it works with these situations.
My question for you, Alex, is it seems like they're, like no matter which way we cut it, I mean the pointer like just keeps going back to them. Now my thing is who is going to be the one paying for it? Now to me, I'm assuming an insurance, but I don't want to be making assumptions when I'm the least intellectual person on this board. So if you, I mean, I'm just looking to, I guess, see who would be paying the final tab, so to speak.
So you're not the least intellectual person. You're just not in this area, right? So
I'll take it.
Yeah, it's you don't. I think a lot of people judge themselves when they don't. They're not fluent or conversant in an area. They think like, oh, they're stupid, or they can't understand it or whatever. And it's like, dude, you didn't spend years doing this. Of course you don't understand it. I'm in the same boat when I go to the doctor, and I have to like, I hope you don't kill me. I hope you know what's wrong with me, and you don't kill me in the process. So you're just in an area that's not your natural field.
See, I appreciate that. See, I know general market plumbing and things of that nature. But there's just so many things going on with this case, and I've been talking about it for quite a while, calling it the most complex play on Wall Street. But beyond normal market dynamics, this thing is just taking twists and turns, and I just obviously rather you guys kind of go over the specifics.
So, are you talking about who pays the bills in terms of the lawsuit, or are you talking about who pays the bills in terms of the penalty?
So there's, to me, it seems like there's going to be a penalty at some point in time. Who ultimately will be the one, I guess, responsible for the wrongdoing, done to retail investors, and who will be the one forking up the cash? If there is anyone forking up the cash, of course.
So the way it works essentially is if you put in all the parties, then the court basically will assign a level of guilt, a percentage of guilt to each party. Like you are 20% responsible, you're 50% responsible, you're 5% responsible. So, and then depending on the jurisdiction, if the amount that the defendants does not equal 50%, then there's no relief. Sometimes though, whatever percentage it adds up to, because sometimes the people suing are also liable, right? They did something that made it worse. I don't think that's the case here, but it happens. So typically what happens is you get an amount that is supposed to be paid to the victims, to the plaintiffs, right? And then for the penalty itself, it's essentially everybody owes the whole amount, typically.
Mm-hmm.
And what happened, that's called joint and severally liable. And so you have to look at your jurisdiction to say, are you only liable up to the percentage of liability that you had? If you had 20% of, $100 million, what do you call it? A punishment. What is the word I'm looking for? But
punitive damage.
Judgment is the word. Yeah, damages or judgment. That's right. If there's $100 million judgment and you're 20% liable, in some jurisdictions you will be found liable only for $20 million. And in others, you'll be liable for $100 million. Like those plaintiffs have to get paid. And you get to indemnify yourself. You get to pull money you sue the other people to get the difference, right? So there's a lot of suits between defendants to make sure that everybody pays what they're supposed to pay. And if you can't pay it, then you get liquidated, basically. If you're an individual or a company, you get liquidated to pay off those judgments. So who would pay, like, for the companies themselves? So often this is an insurance thing. So if they have D&O insurance, and this is not an exception to the insurance, right? There's always exceptions that are like, if you act negligently or recklessly, depending on the policy, then they don't have to pay. And the insurance companies are very, very good at figuring out where that line was. So it's going to matter a lot if this goes to a lawsuit. It will matter a lot how liable they are and what the case actually showed. Because if it showed that they should have done something, they knew they were supposed to do it and they just didn't do it, then very often those insurance companies don't have to pay, because they don't have to pay for intentional crime. They pay for basically errors and omissions. That's it.
That kind of brings up another question that I personally have. Obviously, a class action would take forever, right? And a lot of us don't see that, right? But just theoretically, right? Are there other over leveraged potential securities that we may be able to bring up proof for said class action if it were to go that far and were to go that route?
Are there other over leveraged are there other outstanding names short?
Yeah. I mean, we obviously know about the tokenization of stocks now, and I mean, obviously there's several securities that we could bring into question, right? But if we were to get clear cut evidence saying that the same parties are responsible for doing this to company XYZ, can we then go ahead and present that in a class action?
I mean, likely, yeah, in any action, that's pattern of behavior. They have a pattern of behavior of flouting their law or their responsibilities. And then you would also look at supervisory abilities. Like, did they lie to the supervisors and cover things up? Or did the supervisors never actually look? Like, all of those things matter. And again, one of the things is that if you actually go through a lawsuit, you have now lawyers with the ability to pull information that you don't have the ability to get as simply a retail investor. There's a lot of documents out there that you have to be a broker dealer or market maker in order to access them. They're just not open to the public, and you can't get those generally unless you have the ability to either, issue a subpoena or something else, like get a deposition filed from someone who has knowledge. Like, you need the power of perjury, essentially, to get a lot of those documents.
So can I ask you a question really quick?
Sure.
Are you familiar with the DTCC's rules, like Rule 3, 4, and 5?
I am sort of familiar with them.
The Rule 3 is the participant qualifications. When Mr. Berto originally made his complaint to the DTCC and to FINRA, this should have immediately taken over, because it did not qualify under their Rule 3 or Rule 1 or 2 because of the fact that it was not somebody within the corporation that did this. Subsequently following that, Rule 4, which is the participant funds and participants investment, a lot of that's like kind of here or there, but when you get in on section 1, but when you get into section 2, which is the actual participant investment, that section through section 6 is very explicit on how they must do things, what has to happen, who's involved. Because like section 4 is the liquidity resources to fund the settlement. You have all of these processes that they have set up in these rules that were clearly abandoned, because any of these would have been enacted. This would have all stopped a long time ago before we got to this point where we are today.
I agree. I mean, I think a lot of well, from what I know, right, I agree. I think, you know, a lot of the basic questions that we discussed earlier of like, you know, how did this even happen? We need to see how the market was originally made. Markets don't just pop up. They take a lot of work to build. So someone did work to build a market for something that wasn't allowed to be traded. Who was that and how? Who were the first people who offered it?
It was GTSX or GSTX. I can look it up and tell you. Hold on, give me just a second.
And just to go ahead and further that, it's actually a very big conflict of interest, because if I'm not mistaken, I think it was the chairman of that company is also on the board of FINRA as well.
Well, we don't know who within the company actually, you know, said go on said action.
Okay, thank you for the correction.
So when I'm looking through this, I have a bunch of notes out, and we've gone so fast. There's so much of this I have to catch up on my notes, because my notes are now pages off. So I do apologize. Give me just a second. It was done by Canaccord Genuity, and let me see. I've got it on my PDF. Hold on just a second. I got to look at my others. I've got paper notes and I've got regular notes. It was done by GTSX and Canaccord Genuity. They created the platform to make it tradable when the merger happened. That was done on June 21st, 2021. And we actually, I was sent the actual screenshot of when it was done, and I have it on my computer. I'm going to pull it up right now. I can tell you the exact time and date it was done through the SEC computer, or through the FINRA computer system. Give me just a moment. I got all these screens up.
You know, I'm just so surprised that they make us do these two-step verifications to, you know, sign into, say, Facebook or sign into whatever, you know. FINRA doesn't have a two-step verification system.
So on the otce.finra.org, there was an entry on 10/6/21 at 9:27 and 2 seconds a.m. The addition of MMTLP Metamaterials Inc. Preferred A. It was set up with no restrictions and was allowed to be entered into the system. So we know exactly when it was done. We know who we believe did it. Is there any way as an attorney that we could go to FINRA and say, because they are government authorized, I know they have special rules, but is there any way that we can force them to actually give us the original files? Because that information they're not releasing, to actually say this was the individual person. We know from Mr. Berta's emails from FINRA that he received that it was not him, and it was clearly not him. And they acknowledged that way back in June of 2021.
So is there a way to force them to reveal information, like really generally speaking? Now remember, DTCC, they're not an agency, right? They're private.
No, this would be FINRA.
For FINRA, an SRO, but regulated.
Right.
So there are basically only two ways you can really get information from them if they don't want to release it, and they have rules for when they will and won't release it. So the first is a FOIA request, so Freedom of Information Act, and then the second is essentially a lawsuit. Those are the main ways, right? Because otherwise, there's not unless they are obligated to release that information to you, There's no other way that I'm aware of that would force them to do this. Now, I'm not a litigator. It may be that litigators have other ways to do this, but these are trickier entities than standard private companies. So you really have to go through you have to go by the book to figure out how to get this stuff, because truthfully, a lot of these agencies and quasi-agencies will be held liable if they give it to you, even if they think you shouldn't have it. Right?
So there was a FOIA request made. I have seen it, and when it showed up, the entire page was blank. It was blacked out. The entire page. There was commas and periods throughout the page that were not blacked out, but minus
Sounds like my old agency.
And so they legitimately blacked out the entire document from what I saw. Now, we know because of the data on the FINRA servers that was public information before it was been not removed, and there is pictures and screenshots of it, that it was those two companies that I said that did go ahead and list it, but it doesn't tell us who in those companies did it, and that's where, like, getting the actual original application, but getting it to where it's unredacted, to where we can see who actually signed it, who were the two individuals that actually signed off on this, because they won't give that information out. And that's what, so I filed in Washington State for a TRO for prohibitive injunctive relief. They didn't really want to hear me. But I was asking for, one of the things I asked for was them to basically put a restraining order on FINRA to stop any and all actions, and to turn over all documents, including internal emails, applications, any type of forms or filings that related to MMTLP to the courts and myself. And they didn't hear my complaint. They basically just pushed it away initially.
Yeah, I mean, this has to be like a well thought out suit. This is really, I mean, that's really the issue, right? To get the information, you need the power of the courts to get it. Unless you have some friendly whistleblower that has access to documents, or you've got someone who's essentially leaking the documents. Leaking that's illegal. I can't advocate anything that's not not a legitimate way. There's still really only those two ways, and the way to get documents is to say a wrong has happened. We can't pinpoint the wrong until we have the documents they alone possess. We need to access those documents, because ordinarily the risk would be failure to basically have a cause of action upon which relief could be stated, which is not necessarily saying you don't have a cause of action. It's just that you can't affirmatively say, here is the cause of action, here are all the elements, and here's how they met them, which is difficult.
But we can do that. We just can't identify a specific person. We can say these two companies on this date and time did this, which caused all of this to happen.
Right.
So we can show the cause of action.
Well, no, but you still can't build your case, because you can't do it against, some parties did this, right? So what you have to do is you have to say, look, we have a specific person, but we need the other side to produce the information so that we can complete our complaint. And that is actually a way that, a lot of courts will do that, right? That you need the information to show that this has happened. If the information isn't there, it automatically doesn't progress farther, and it's usually dismissed with prejudice, which means you can't actually bring the action again. So,
right. So you can't go and say that because you're filing against the companies themselves, that these companies did this, and we are stating that these two specific companies on this date and time broke this law and did this, and we are asking for FINRA to release the actual paper application so we can find the actual bad actors within those companies?
Exactly. So you would name the company, you would name the entities themselves. And then you would
and
say,
that's what I tried to do.
We don't have individuals within there because they hold those entities. You actually also can't definitively say something like, well, he never signed it and it was fraud. I mean, you need a few things to back that up, right? You need like, an affidavit from
Mr. Berta.
Right, and then you also need on the other side, you need to see what actually, what transpired there. So you can't definitively say that something went wrong until you have the documents. So, but again, that's not really a reason to not file. That's just, you need to file, but knowing that there's more information you need to get, and the court has to grant, you ask the court to grant you a certain amount of leeway, get initial documents to complete your filing.
Sure, and I mean, I have my statement from Mr. Berta, and I did include that. They just, like I said, they had their own reasons on why they did what they did. And I'm not done with it. I'm going to keep pursuing it. I won't beat a dead horse because you have gone over so much information. Can we go over a couple of things really quickly so that people can understand some of the information that's being misunderstood? Can I run some things by you?
By me?
Yeah.
Sure.
Okay.
Again, none of this is legal advice. I'm not a litigator. Sure. I'm not, an involved party. I'm just
an opinion. Just an opinion.
This is just process information on how some of these processes work, not specifically to any one thing. So, and I'll explain. So, there's a lot of people that are saying because of what's written on FINRA and the DTCC that your broker actually holds the master book on the shares. But we know that that's not correct because the the rules say that the broker must keep the identifier number and they must keep it on their books. But it also says that the transfer agent for the original corporation that holds the master book, they're the ones that when the DTCC gets a request to take this security from, say, my account and give it to yours because you bought it, and we have different companies that represent us as far as on the stock market. I have, say, Schwab, and you have, say, E-Trade. They're going to, E-Trade and Schwab are going to get with the DTCC, who's going to get with the NSCC, and they're going to make that transaction happen. Part of that transaction is those entities are going to contact the original master book holder and say, we're moving this share from here to here, because they still have to keep an accurate accounting of where those go, even though the brokers are required to keep an accounting as well.
So yes, the master account, the listing of all the holders is held by the transfer agent, and generally also a copy is held with the secretary of the company. And that is passed along, giving, if there's a merger or some other event, to the extent that there are shareholders that carry over, those shareholders are then transferred over to the new company's books, et cetera. But yes,
correct. There's just a lot of people saying that, the AST has no idea who has what shares where, because the broker dealers actually pass those around and they don't get them to the very end. And I'm like, that's not correct. There are multiple copies of these books, and there's ways that these processes work. And so that's what I was hoping you would touch on, is just how they kind of work, because that's where a lot of people are trying to confuse other people, and they don't really understand. They're speaking on things that they're confusing things and making people call their brokers and ask for things that are not real, and the process doesn't work that way.
Yeah, this happens a lot. It's a confusing process, I think, maybe so people don't necessarily understand how it happens, but it's worse when you get a bunch of people who don't know what that they do, and that, this is the expertise issue that we had before. So generally speaking, yes. So the transfer agent is the record keeper, right? They're the ones that say if your shares are private, okay, if you're going to transfer them, you need a legal opinion. In order to do that, they check to make sure the documentation is there before they do the transfer.
Correct.
They are procedural people. They do not initiate transactions on their own. What they do is make sure that the transaction is legal and is essentially entered. That's what they do. So
Thank you so much.
And then the secretary usually has, I mean, now it's an electronic record. They used to be like physical records that you had to meet with the transfer agent, update everything. It was like, I did not do securities in these at all. I've only been electronic, right? But I can't even imagine how hard that would be, especially with different people's writing and stuff. But so generally speaking, there's a constant updated copy that is kept with the secretary so that they're always aware of their cap table, right? This is the issue for the company is different than the issue for the transfer agent. The brokers have whatever accounts you leave with them in whatever capacity you leave them, right? So the brokers have essentially the shares that you leave with them that if you give them the authority to trade on your behalf, then you have to say, are they just executing on your behalf? Are they making the actual trades on your behalf? Like who's organizing the transfer, right? Is it the broker or the individual? So then what they do is all they can do is whatever you authorize them to do. If you're the one who initiates the trade, then they execute on your behalf. They're allowed to directly interact with the market. And you say, do this, like go and buy whatever, right? And it may be that your broker is not actually the broker is an order book, and then there's a broker removed from, like one step beyond that. There are lots of ways that this happens, but essentially it all ends up at some broker who then has to do, say you asked for a short position, they have to execute it, but they can't execute it until they've met all of their requirements to execute a short trade. Now, most of these, if they've done it for any small amount of time, they should know them automatically, and they go and they seek, where these shares are, whether or not they can attach them, and then commence a borrow if you need that. Sometimes they will say, we don't borrow or we won't let you borrow. You have to go and purchase on the market and then sell. So there's a lot of different things that may happen. That is determined by the policies of the broker and the facts of the circumstances of whatever it is that happened. But that's all the broker is. They basically know what exists in their pool of people. So they may have the shares available, but from another customer. But they only know what happens in their pool of people. And then they have access to, the DTCC, the clearinghouse records, that also will say, at the end of the day, usually I think once a day, it might be more often, but say, it's like what I think of is like a library kind of listing where a bunch of books come in and it's gone out, and at the end of the day there's kind of a reconciliation, and they say, okay, here are all the shares that are outstanding and who owns them, and say, yes, I can locate a share, or no, there's no shares on the market, etc. So they also have access to the reconciliation list. That's not what they're called, that's what they are in my head. So
No, correct.
Yeah, so that's what they have access to. They do not have access to the transfer agent beyond informing them that a trade has been completed. That's it.
Right.
They don't have any other access to them.
So I do want to clarify one thing that you said, though. The major shareholder of the corporation of the DTCC was the original shareholder, or was the last owner of TD Ameritrade as a corporate entity before it changed over to Schwab. So I would say that they possibly had access to more information than the other broker dealers because they're within the same corporate heading. But I have no way to say whether they were sharing information between their own companies.
I don't know. That would be, there's a measure of violation there. These are separate entities, but I don't know the facts of that. Of whether I can speculate as to whether or not that was true.
Sure.
But yeah, but information flowing outside of legitimate channels happens, and I think we'd be naive to think it doesn't.
But I think that I do want to say that I think that that's the problem, and that brings me to why I wanted to make this video, is because I wanted legitimate information, and you guys are absolutely crushing it and informing so many people. So I just want to say thank you for that, absolutely. But all of that, it kind of leads me to one question, and is that should we be pursuing these cases on our own, or should we be looking for a class action? And if
Somebody can't give you legal advice.
well, I understand, but I guess own opinion, right? Is say that you were stuck in a situation. Would you be filing on your own, or do you think that there's a a good thing with numbers?
For me personally, I think that it's about numbers. There's basically
Okay.
two actions that could be taken. One is a derivative action, which is the shareholders basically on behalf of the company, and then the company gets whatever compensation is earned, and then hopefully there's an arrangement to distribute some of that or some of the benefit of that to the shareholders, right? So that's derivative. And there's a direct action where you're basically suing all the parties involved up to and including the company, and then just getting your compensation from there. And that's there's more advantage than disadvantage in filing a suit, especially in large numbers. Even if you wanted to file individually, at some point the entities would basically say, we want to merge all these. They all evolved from the same cause of action. They all involve the same facts. We want to merge all of these cases into one. So you kind of would have, the option. This is not the same as a class action. This is people acting as a class, but this is not the same as like a tortious action like that. This is a right that you have when you're a shareholder to file a suit for your rights because you're an owner.
That right there was just beautifully said, Alex. Thank you very much. Exactly how you just phrased that. That was beautifully said.
Alex, can I ask you something really quick too?
Sure.
I have another question for you. So I'm involved in something with my broker. I'm not going to say who they are, unless you want me to, or I don't know. I'll just leave them as just a broker at this point for the conversation. But I called my broker roughly the beginning of November, and I said I want to transfer X amount of shares through this type of transfer, and I want it done this way. And they pretty much gave me the runaround, and it took almost 17 hours. I logged my time on the phone between that brokerage and AST. I finally got frustrated, and I three-way called them together and got them both on the phone at the same time. And when I did that, the rep from AST was able to confirm the way I was telling them to do it, and with her on the phone, she gave me very specific language. I used it. They transferred my shares. Well, fast forward almost a month to December 5th, and I called them because I was getting nervous about how things were going, and I was watching the price of the security, and I read the S1 and I knew what was in there. I knew what it said. And so I called them up and I said, hey, I want you to do this type of transfer. And they said, oh, no, that's an inbound only. We don't do that. You got to go this other route. And I said, stop. I'll send you this email you guys sent me, because I have an actual email outlining exactly the process they used, because I requested it when they did my transfer. And so I shared that with the representative, and they were supposed to have done my transfer. Well, I got an email the next day saying, hey, we were unable to do your transfer through this other system, which I knew was incorrect anyway. And so I called them back. Now it's because of the email time and my schedule. By the time I got back to it, the chill had happened and the U3 halt had happened. It had been just a couple of days. And so I called them and I said, hey, you guys did this when I specifically requested it to be done this way. Can you look through the notes and talk to me on this? And the guy's like, well, no, we didn't do that, and gave me the runaround. 30 minutes into the phone call, and I did let him know I was recording it, and I let him know that I was recording it specifically to use in legal action if I needed to. And so I had his consent to continue the phone call. When I was talking with him, he advised me that my transfer was done incorrectly, intentionally, because they knew something was coming, whether it was going to be a halt, a corporate action. They knew something was about to happen, and they didn't know how it was going to affect them, so they did not finalize my request. So I am taking action against them for fiduciary fraud. And my question is, how many people do you think in other brokerages this has happened to? Because when I called them back, and the guy admitted that they did it specifically because they didn't know what was going to happen and they had to protect themselves. That was his actual words on the phone call. So I got concerned that they were going to throw this guy under the bus and say, hey, this guy doesn't know anything. He had no right to say that. We fired him, whatever. So I called him back, and I got a guy from the trading desk who had a Series 7 license. And I talked with him, and I let him know the same things. It's recorded. I had him read the previous notes, and I said, this representative told me this. And he's like, I see that. And I said, so is this correct that this is what was done? And he says, well, yeah. And I said, well, isn't that the definition of fiduciary fraud? And he says, well, yeah, but I can't comment on that. And I said, well, you just did. And he says, well, yeah, I mean, it is fiduciary fraud, but I can't outright say it. And I said, well, you just actually did, though, sir. And he goes, yeah, but not as an official comment, just as I'm agreeing with you that this was done to you and this was wrong. So I have that recording. I'm concerned that there's a lot of people that don't understand how this works. And if there's do you believe there are other people that tried to transfer that were intentionally misled for the sole purpose of them being able to protect their own profits?
I have no idea. I have no way of knowing how many people wanted to conduct any sort of transaction at any time with any brokerage. Sure. So it's impossible for me to even speculate on it. Okay. I would say though that brokers do have they have a distinct conflict of interest requirement, right? Which is that they always have to act on the best interests of their clients, right? Even when it hurts them. That's the whole thing, right? That's different than like what financial advisors have, which is just to make sure that the option is suitable, right? There's something more important and better that you get when you work with a broker, and that is that they're not allowed to put their interests first. So, regardless of why or anything like that, I mean, the fact that he said they put the broker's interests above yours is, why would they say that? That just doesn't. Okay, great, thank you.
I mean,
that's very damning.
That's just.
And here's the thing: I understand the laws because number one, I was an investigator for a number of years. The other thing I worked for another company that was basically purchased by Citigroup. And at that time, I had my window open, and I was studying. I opened my window, and I was studying for my 6, my 63, and my Series 7 licenses. I did not finish doing my licenses. I had another child, and my life got extremely complicated. And I moved on to something that was a little easier for me, and I stayed in the mortgage business. And so for me, I had firsthand knowledge of exactly what he was saying to me. And I'm just concerned that there's a lot of people that don't understand what the laws are, and that they may be in a similar situation and not even understand the situation they're in.
Yeah, I mean, I don't know what to say other than, maybe tell as many people as possible,
Okay.
Find out if they had any transactions, if they were not closed, and they were, the transactions were not conducted, and there was some sort of, either fraudulent component, or there was a component where they were not putting the interests of the investor first. I don't know. I mean, that's going to be something that's a broader scope than I have. And to be honest, the people who are best suited to do that are basically SEC enforcement. They're the best people to go and figure out exactly how often that happened and to whom and what the rights are and whether or not they should just, de facto declare some sort
So
of
so
benefit.
what I'm hearing is first, and not your professional opinion. First, it might be in our best interest in order to go ahead and get a class action rolling. That may not be what we want to do, but that might be what we have to do. And then secondly, it sounds like we have to go ahead and like, sub, and share this video nice and wide. That way everybody gets correct information, because illegitimate information seems to be tearing apart the community.
No, I agree with that. I disagree that we can start a class action, because as of right now, because this is not settled, there is not a definitive victim yet. So
Okay.
that's that I believe, and I'm not an attorney, but I believe that has to wait until some action is taken.
I would actually say that you could probably file a direct action now, simply based on the fact that you're supposed to get a distribution of shares.
Okay.
That didn't happen before the shares were canceled.
Okay.
So, and then doesn't, you don't know who made the decision or what, and that's really not on the investors to determine. You just
Sure.
have to show that somebody in this group of people did something. And,
right.
we can they can all gather information on each other. You can gather some of the information, and then they'll do the rest to protect themselves. So, that's just kind of what happens. It's unfortunate that it requires this kind of thing, that there isn't a way to get some information, or at least to protect your rights. But the truth is, this is how, at least in America, the legal system works. Laws aren't magical, right? They're only worth what you are willing to do to enforce them. So,
Or what you can prove, right?
Or what?
Or what you can prove.
Well, yeah, assuming you can prove something, it doesn't even matter if you're not willing to take it to court.
Mm-hmm.
And that doesn't mean you have to go through a whole court thing. You can settle. There's all sorts of different ways that, it can be resolved. But truthfully, there are people who spend fortunes on getting a patent or something like that. And then some large company says, okay, great, I'm going to do that same thing. If you have no money to enforce your patent is effectively worthless. That is a really important concept, is that rights only give you a hook to sue. They give you an accountability hook. But that accountability hook is meaningless if you don't exercise it. That's the premise of American law. And
100%.
Yeah, there's just, I don't know that there's a much better system, to be honest, because you don't want some third party randomly saying, I'm going to, give that person's money to this person, right? You don't want that to happen. You want there to be a process for that to happen, and for evidence to be required, things like that. So, I don't know that it's great, but I don't know that there's a better system. So it's kind of where we are right now, and if nothing else, getting it started gives you rights to access documents that can make your claim better or show that there is no claim. So it's a really important process just to get to discovery.
And as you said, during discovery, we have the chance to present other factual information based on the way that they've treated retail in the past, correct?
So that would be under something where part of an element of your case is pattern of behavior. Otherwise, what you have is something that you can present to rebut something at court. So this is something that litigators are going to love diving into. Evidence is an entire class of, specialists who understand all the rules of evidence in civil litigation versus criminal litigation. It's a huge area, but not all evidence is used to make your case. There's a lot of evidence that's used to rebut the other side or to shore up your case, but not make the case. So you just don't expect everything that you find to be like, here, yay, look, they did something wrong. But if that wasn't your cause of action, then that's not something that can really benefit you unless it helps you under attack. So that's kind of a really rough explanation. I can hear litigators going, "What? There's so much better way to say it." Yes, I know. I'm doing the best I can here.
No, I appreciate that a lot. For my case personally with me, I went and I filed a whistleblower complaint. I helped another person file one as well. I filed mine against the two entities that started this trading, and I turned over the proof that I had and the stuff that Mr. Berta gave me as well. And so I used those documents with the SEC, and I've been in contact with their investigations department personally, and they are reviewing it. Whether they're going to do something with it or not has yet to be seen, but I at least know it's in their hands, and their attorneys are looking at it, and their investigations department is looking at it. And that's the best I can do with mine, is just file those, and then I have a private attorney that I hired, I believe. I'm just waiting to get final confirmation from him this afternoon that he is going to take my case against my brokerage for the fiduciary fraud. That is not something I feel like I can tackle on my own. So I did reach out to a securities attorney for that. And I think that's really important that people understand that filing like a whistleblower complaint or filing a complaint in the court is one thing, but if you're going to actually go after something that can really harm your chances of winning and you only have one shot at it, you should absolutely at least consult legal advice first.
Oh my God, yes, absolutely. If you're definitely talk to a lawyer, and not someone who said, well, I basically watch every season of Law and Order again. Not so you want to make sure that there's somebody who understands the law. Remember, if you file a suit, and I have been a plaintiff in a couple of suits. I do it very, very rarely. But when I have to, I have to. You got to be in it for the long haul, right? You got to know that it's years. It could be years before your case goes to trial. Like, for real, it's years. And especially if you're relying on the SEC, which, by the way, you won't get compensation, but you can get justice. The SEC, when they're right now prosecuting stuff that was filed originally, like the original complaints and investigations started in 2018. The actions occurred in 2018. So just know that things can take a little while. You have to just be patient, be prompt in responding to anything your attorney tells you you need to get. You need to get this back to someone or whatever. Do that right away. Don't let the ball sit in your court, because that's just going to lengthen the time. Remember, people go on vacation, all sorts of stuff happens, so you just want to move it along as much as possible.
No, I agree. I do have something that I did want to remind you of. You were wanting to address Neil before he was on the call. Do you remember?
Me?
Yeah.
Oh God. I don't remember.
Okay. So you were wondering.
I don't remember.
If there was...
Alex, I'll tell you what. I'll jump in and save you real fast. The real issue when you start looking at all these things from an individual standpoint, you systemically are at a macro level looking at something that is happening all across the board. Example, FINRA. That is the Fox Garden hen house, right? You can sit there and look at shorts, and when you see an FINA symbol come up, you can say naked shorts right here. And what are they doing? Oh, okay, they're selling off the top, so I need to sell right now. And then when they hit it down and start covering, I need to go down and cover. I kind of nickname it shorting the shorts. But you see that across so many small corporations that have been driven down sub-dollar that should, just selling their hardware alone would put them over several dollars of valuation.
That kind of brings us to like a different topic, unless we want to talk
hang on
MMTLP.
just a second, Jonathan.
Go ahead.
On. give me just a second. Alex, you were asking earlier if Neil had any access to any of the other hedge funds
No,
and the people in that community.
Market makers. I said
Yes.
it'd be
Okay, that's what it was, the market makers. So go ahead.
Do you know any market makers that might be involved that you know, it'd be interesting to talk to them and find out what their opinion and what their side is.
The people I know, I've been at it for a while. The people I know are basically gone. You know, you get that 5-year sort of thing, and people depart. They move up, they move around. So getting them directly becomes an issue. But
You know, what I thought of as soon as you said that, they're gone. I thought that like everybody that you know that worked there was mysteriously dead.
you know, it's.
I was like, oh no!
I would be surprised if some of these large market makers actually do that on purpose to further confuse these smaller cases or these class action suits to, you know, person's not here. Well, we don't know who it was. And that's the sort of thing it wouldn't surprise me. The private guys, yeah, there's still a lot of private guys around, but the larger people, other than, you know, here's Fidelity or someone like that, they move, especially at the government side of it. They're moving all the time.
But by moving, what exactly do you mean, Neil? Can you kind of like elaborate on that?
A job to another company. I mean, let's face it, Alex. If you were offered a higher 6-figure salary next door, would you go take it?
Well, I mean, that's exactly what happens at the SEC, right? Literally get asked it, you know, like people are recruiting you while they're, you know, trying to do a deal, like, you know, that's getting through. You're like, that's not appropriate, but yeah, I mean, recruiters call all the time, and you know, in a hot market particularly, like I tripled my salary the day I left. Like,
well, congratulations, Alex.
I was like, yay for me.
Yeah, but that happens all across the board.
Yeah, I mean, it is an issue. There are a lot of issues in there that that's a whole conversation of like discrepancy in salaries and things like that. And then, you know, what is the incentive for flow between the public and private sectors? And if there's no incentive, the problem is the information gets stuck on either side, and so both are unnaturally wary of one another when instead they should actually be working together. So there's a lot there to unpack. Unfortunately, I actually have to go. I'm actually a little bit late now. But this was a wonderful conversation. I really appreciate it. Again, there's no legal advice, no financial or investment advice.
Oh, absolutely not. I appreciate you so much so much for your time and taking your time to try to, you know, just bust through the you know, the FUD that, you know, is being spread around. So I just want to say thank you very, very much for taking your time and hanging out with us. And
I do too, Alex. Thank you so very much for responding today and for being able to be here with us. Your wealth of knowledge is invaluable.
And I would love to talk to you about your initiative in the crypto space as well. So maybe, you know, we could plan something out regarding that as well.
That'd be awesome. I'm happy to talk about it. Ordinarily, like, that's like my favorite topic of conversation. There's so much interesting, fun stuff happening. But I think this was useful. I hope it was useful.
It absolutely was. But now you have me looking forward to our crypto talk.
Yay, crypto! It's not all fraud. Anyway, thank you so much, and I will I'll probably speak with. I mean.
You'll speak with one of us. I'm sure people are gonna have questions, and you know, we'll handle it, you know, accordingly.
Groovy. I'll talk to you guys
You
later.
were amazing. Thank you, Alex.
Thank you,
My
Alex.
pleasure.
Hey, try not to have too much fun.
Gentlemen, I just want to thank you very much for your time. I know that she did a lot of the talking, but and mental and Alan, you proved a lot of excellent points. Neil, you were there to kind of be like the devil on the shoulder and talk about market theory when I was unable to. So I just want to thank you very much for your professionalism.
Before you end this real quick.
Oh, absolutely. Go ahead.
Neil, is there anything that you heard that you want to touch on, or that you want to say, hey, this I heard, but maybe it wasn't fully complete? There was something I heard that I want to add something to?
No, because most of what Alex had to say started going into the legal side of the house, and that's where I'm totally out of it.
That's where you had your attorneys, right?
Yeah, that's why you have attorneys, yes. But all of the talk actually, caused me to look at the macro level on these things, and because this is a systemic issue everywhere.
I agree.
Seconded.
And so it needs to be, the big stuff needs to be fixed in order for all these little things not to happen.
Mm-hmm.
I absolutely agree.
All right. So
I believe they've opened the door for us to be able to prove a lot of things in a lot of different places, and when the discovery does happen, I think it's going to be jaw-dropping for the people that understand the market on a level like yourself. I kind of understand it. I do not call myself a professional. I've done research. Like I said, I was studying for my licenses, but I am in no way on the level that you are or some of these people I've talked to that are up to like a Series 24, and they have knowledge and you have knowledge that just I think is going to be invaluable once we start disseminating the information that we're getting from our court cases for the ones that do start to collect discovery.
Yeah. Hey, Neil, thanks for being on our side. Just saying.
Well, it's what really kind of needs to happen. The news about those individual cases is a good yes. But what you need is someone who can actually go in at the SEC level and get someone to, put the proverbial boot up someone's backside and get things done.
And I believe I have that in the works.
Right. But, when she was talking FINRA, well, you're talking a board member that's...
It's an SRO, too.
Works at the SEC.
Yeah,
Right.
Well, yeah, it's an SRO, which is underneath the SEC, so I get that. I get where you're coming from there.
Well, no, but he's talking about you have a board member that works on both, and that's
that's a complete conflict of interest.
Yeah, but no one calls that ball.
Well, and there's also people that are creating these issues that are on the board at FINRA that are literally responsible for these things.
As I said, look at that FINA on level 2. That's
Correct.
your shorts, and they're all naked.
Yes, sir.
So that's why I say you've got the fox guarding the hen house.
100%, sir. I could not have said it better.
And he is ripping every hen a new backside.
And like I said, I've turned over the documentation I have to the SEC. I have physically talked with somebody from the investigations department. I know that their attorneys are now involved, and they are looking at my complaint. And a matter of fact, they helped me file my complaint in a way that would route it directly to the attorneys like the same day. And I believe that because my resolution that I've come up with. I didn't just file a complaint. I also filed in my whistleblower complaint. I gave them what I believe is a way to correct this problem. And I think they are looking at that very seriously to see if it's viable. Because it allows them to be the good guys. They're going to have to sacrifice a few of these hedgie guys that did some things that were illegal, but that's going to happen inevitably. Whether they sacrifice a few now or they sacrifice them all later, it's not going to matter. In the way that they conduct business, I believe they want to look like the good guys, and that they want to. This mess has been dropped on their doorstep now, and I believe that they want it to go away.
The big thing is it's public now.
Yes, I believe they want to put it behind closed doors and make it go away. So,
yeah, so they're going to do something when they're, in the limelight with that.
Sure.
Even Congress is talking about holding committee hearings and those sorts of things.
They're already happening because I've been turning over information to committees that have been happening for about 3.5 weeks now.
Super. But like I said, it is getting those things apart. Shorting one stock 10 cents twice a day with a company like FINRA or any of these other capital companies, they do it by the thousands in a single day.
Right.
And now, how much money is that bringing in?
Yeah, and all they're doing is bloating the floats of these companies.
Well, they're pocketing the money.
Well, yeah.
And they're allowing the retail to be destroyed, while the people on top go get new Learjets and buy another house for their third girlfriend so they can hide them from the other two plus the wife.
Yeah, and that's basically it. But it is a fast way to make a lot of money. Those nickels and dimes add up.
Especially when you're talking about doing it thousands of times a day.
And, Neil, I am really happy that, on our last interview, you had actually said that, from a moral standpoint, you stand on the side of, feeling that shorting is just unethical. So I just want to, obviously, as a former hedge fund owner, obviously, thank you for that. Because not only do I agree with you, but I, implore that, I wish that other people, had that same heart.
Yep. Well, I'm going to let you guys go. Neil, thank you so much for your time. Your information.
I got to go heat up dinner for someone who's been working her side of the house all day.
No worries. I just want to let you know how valuable we find your information to be as well. You bring a different perspective to this that most people will never understand. And that is, you can't buy that kind of knowledge with any amount of money. So I really, really want to thank you from the bottom of my heart from coming out here and putting in the input you have put in, because it is absolutely, there's no words for it, how much it means to us that we have somebody that is like, I'll explain the things you don't understand. Man, I appreciate you so much.
Absolutely. And thank you for doing it here, by the way. Thank you very much for doing it here.
You guys just try not to have too much fun either. I know, because I'm signing off.
All right. Good
night. All right. Hey, you guys have a great night, and I'm sure I'll talk to you guys in a little bit. So, I personally think that was a great phone call. I just want to go ahead and say that Matt Kors was supposed to be on the call with us. I'm going to go ahead over here, and we'll just go to my Twitter. That's fine. Matt said that he was going to be on my Twitter or on that call. Feel free to come to Buzz the Margin call, okay? BUZZMARGINCALL. He said he was going to be here. He wanted to learn more about MMTLP, but he's nowhere to be found. Yeah, I just want to let you know that you are the reason why I actually have my own, I have my own space. About a year and a half ago, maybe 2 years ago, you actually said, if you think that you could do a better job, then why don't you go start your own channel? And I just want to let you know, thank you very much, because that's exactly what I did. I came and I started and I made my own channel. So thank you very much from the bottom of my heart, Matt. You changed my life in that regard, but I wish that you would have come on the call in order to be educated, because not only would you have been educated, but I myself was educated as well, and I think that that was a little miscommunication that you may have taken the wrong way. But thank you, everybody. I appreciate your time, and I'm gonna go ahead and I'm gonna sign off. Thanks, guys.